Wow, what news on Friday, May 25th, 2018, affecting federal employees and virtually all federal agencies. And this has to do with the executive orders that were signed by President Trump. And the one I want to focus on in today's podcast is the executive order, which he calls Promoting Accountability and Streamlining Removal Procedures Consistent with Merit Systems Principles. One of the pledges that President Trump had made was that he was going to make the federal government more accountable, more efficient. And one of the things he has done in this executive order is make it far easier for federal agencies to terminate employees based on poor performance or allegations of poor performance. Now, generally, there are two methods in which agencies terminate employees for poor performance. The most common one is what's called a 43 action. And this is this Chapter 43 is your classic underperformance, and it requires a performance improvement plan, and it's appealable to the Merit Systems Protection Board. And agencies like to use it as opposed to what's called a Chapter 75 removal, because the standard of evidence that they have to show in a Chapter 43 removal is generally lower. For one thing, they don't have to show this element of this will further the efficiency of the service, which is really big under these Chapter 75s. And the performance improvement plan was shortened from 60 to 120 days to 30 days. In fact, I'll read to you the Section 4 of the executive order, which says managing the federal workforce to promote good morale in the federal workforce, employee accountability and high performance, and to ensure the effective and efficient accomplishment of agency missions and the efficiency of the federal service to the extent consistent with law. No agency shall. And then if you look at C, subsection C, says generally afford an employee more than a 30-day period to demonstrate acceptable performance under Section 4302C6 of Title V U.S. Code. And then it does give an exception, except when the agency determines in its sole and exclusive discretion that a longer period is necessary to provide sufficient time to evaluate an employee's performance. Which means this: let's say the agency tells the federal employee, yeah, you're doing a lousy job at this job, and you're on a performance improvement plan, which they have to give you in Chapter 43 actions, and you have 30 days to improve or you're out of here. Okay, so the first issue is, could someone show improvement in 30 days in a typical federal job? I don't know that a lot of jobs in the federal government, the federal employee could possibly show improvement. A lot of federal employees are working on long-range projects or had some issue that had to do with judgments 4 months ago, and then that issue just doesn't come up again. So that's going to be a point of litigation. But you don't want to get these performance improvement plans in the first place. I mean, I think that shortening the period from potentially 120 days down to 30 days, okay, really does put an emphasis and the onus on the federal employee to take care of these things right away. You as a federal employee have to assume that the agency is going to argue that you could have shown performance improvement within 30 days and you didn't. And that's why. Now, what should you be doing in order to not get these performance improvement plans in the first place, which is going to be really crucial? The first thing you've got to do is monitor your own performance. I tell this to my clients all the time, who, whether they work for the federal government or they work in private industry, keep a log. What are you doing? How are you doing on those projects? If your supervisor says, great job, terrific, keep a note of that. Okay, don't count on the organization keeping these emails longer than they need to. Another element that's really important, and particularly for federal employees, is this issue of training. That is going to be very key. And I see this pattern a lot. I see federal employees who had successful careers working in one job series for many years. The federal employee wanted to advance his or her own career. So what he or she did was apply for another job at a higher grade level in a different job series. Got the job. And then they come to my office like 6 months later and wow, they're really underwater at the job. Well, what happened over there? How does a federal employee who had such an excellent track record for many years all of a sudden be considered a screw-up? And I think one answer is very simple. The employee didn't get the proper training that the employee needed to do that job. So you have to really monitor, are you getting the training? And if you're not getting the training or the training's not effective, you absolutely have to put that in writing to your supervisor because that's going to be a key in rating your performance. Also, of course, your appraisal is very important. Any kind of performance, whether it's quarterly, semi-annual, however it is that your supervisor keeps track of your performance before your yearly annual evaluation, you absolutely have to monitor that, and you have to challenge it if you think that the supervisor is wrong. And finally, the message that I'll say, because we do get a number of these calls from people all over the country who are in performance improvement plans with different agencies across the United States. If you get one of these things now in the future, you absolutely have to call a lawyer right away. I mean, if you have a 30-day PIP and you sit on it for a week or two, that's all it takes. Even a week of not really having the benefit of an attorney giving you the tools to fight the performance improvement plan, your chances of getting eliminated from that job rise substantially. So absolutely, if you get a PIP, give us a call and we will give you these tools that you need to keep your job and to, in fact, have a successful career at your federal agency.